Senator Mizell.
Thank you, Mr. Chairman, Acting Vice Chairman.
Good morning. I'll take it however.
Yeah. Thank you, committee.
Tell us a little bit about Senate Bill 194.
Oh, I was waiting for somebody to read I can just jump in.
Yeah, come on.
Okay.
Tell us a little bit about it.
Okay. If I could, I'd kind of like to bring you how we arrived at where we are today. There's been several transformations of this bill, but the bill basically addressed the fact that since 1996, the law in Louisiana has said that 21 is the legal age to drink. The bill originally wanted to make it where only people that were of legal drinking age could enter a bar. We've changed the bill necessarily because of the opposition, and now we're trying to make it clear that it affects bars that serve a minor, which basically is in itself breaking the law, and then the minor is harmed or causes harm to a third party. Right now, the law is silent on that. The bill in its current form would allow clarity on that. We have, I believe, created what would be a dram shop law situation where 45 other states have dram shop laws. Louisiana currently does not allow for that. Alabama, I think, is a great example of the dram shop law. It applies to customers of all ages. We're just asking that the dram shop law apply to establishments that serve underage people, not even legally doing something that should not be practiced. So it basically makes a business that serves alcohol liable to anyone injured by having served that person, causing intoxication or injuries. And if I could, I want to make sure we know that the bill is just a baby step. It's addressing a loophole, and it's doing that in a way that addresses tragedies we've seen. Basically, we've been told, as we've worked on this, that any restrictions that are put on the way Louisiana currently handles the practice would cause unintended consequences. But we've all seen unintended consequences of the way it's done right now. I mean, we've got heartbreak of people in the room today that have felt that, and so those are the consequences of allowing the loopholes that we've got. So we know that one single bar's license was revoked, but then we also know that the practice continues, and underage drinkers feel the repercussions of it. If you
I think you have an amendment.
An amendment, yes.
I'm going to offer the amendment. Let's get staff to read it in and then get the bill in the proper posture. And we get the amendment passed out while Ms. Lewis tells us a little bit about it.
All righty. So, members, there's just one set of amendments on this bill, set number 3544, which the committee secretary is distributing to you now. This set of amendments makes several technical changes substantively. If you look at amendment number 12, it removes the prohibition of a right of action for an underage person who misrepresents his age. And the amendments also add to the powers of the ATT commissioner.
If I could say, the intent of the amendment was to direct the bill toward all establishments where alcohol beverages are the principal commodity sold or served on premises for consumption. And that was the clarity brought about by the amendment. Included in the amendment is some accountability from the ATC as far as numbers to be reported, and it continues with the scanner, which was mentioned in the bill previously.
Any questions on the amendment? Representative Edmondson, no. Representative Ojai, you have a question on the amendment?
Yes, Mr. Vice Chair. Thank you. How would like Nola Brewery, like a brewery that has a front end where they sell beer that I might take my 15-year-old nephew to? Their main focus is not I mean, their main focus is the production, the manufacturer of beer. But would this amendment disallow my 15-year-old nephew to accompany me, and him get a Coke, I get a beer, and we each get hot dogs or something like that?
Manufacturers are not included in this.
Okay.
This is strictly the Class A general retail permit establishment. So if a portion of that, and I'm not sure how the establishment is set up, because
Right.
you're talking about a very specific place.
Most microbreweries and brew houses that
Right,
have a
if they're
front
a
end.
manufacturing
Amendment.
facility, they are not included.
Okay. And restaurants with bars?
No restaurants.
Okay. No more questions. Thank you.
And I think the difference is where it's an establishment where alcoholic beverages are the principal commodity. So they're the level of definition within the facility is based on whether alcohol is primarily what they do.
Gotcha. Thank you.
Okay, Representative. I don't think Representative Adamson, your question is on the bill, not the amendment, right? Okay. The chair has offered the amendment. Is the opposite? Oh, I'm sorry, Representative Presley. I didn't see you. Hang on just a minute. Representative Presley.
Thank you, Mr. Vice Chair, and thank you, Senator. So I just want to clarify on Representative Ogeron's. So manufacturing is not included. So that means none of the breweries that their principal occupation of the drinking, the consumption being done there is drinking, right?
Well,
I mean, they're also manufacturing, but certainly the brew side is, or the brewery side is, and at least the ones I've frequented, there's a brewery in the back, and there's almost a bar in the front. Is that
the classification is different with
Okay.
the ATC.
Can you
And
expand upon that a little bit of what the classification difference
The
is?
reasoning there is that the establishment's primary function is not that most of their financial benefit is not from what they serve in that establishment, and the concern was that we're kind of muddying the water, if you'll allow me to use that expression, because it's the concern we have are places that serve high content alcohol and low content alcohol. The focus on the breweries is the low content alcohol. And the concern there was not the serving underage. What we would be doing is, just as Representative Orgeron mentioned, you'd be taking the family component totally out of the ability of the
So if a bar opened that was just serving beer and wine, I assume that's what we're defining as low content alcohol, as opposed to having hard
High
liquor
and low
as
instead.
well. Then would they still be classified under on the brewery exception?
I haven't heard that example before. I wouldn't think so, because breweries are they're not a Class A. A Class A establishment is a retail establishment strictly serving high or low alcohol content. So I'm not sure when you talk about just a low content whether that would be considered a Class A.
Okay. And I know, I think in this committee this year we've had some bills that are adding distilleries to the same manufacturing exceptions, I guess, as the
Heard of it with the
breweries.
samples of where they have the sample tasting rooms. and
Right.
what have you.
Exactly.
Right.
Exactly. So would
Right.
those...
I don't believe
How would
those
those
are considered
qualify?
retail establishments such as a bar.
Okay.
That's why we kept it very clearly contained between a Class A general license.
Okay. So the distilleries that are serving the high-end alcohol would not be under this requirement to
Not to my knowledge, no.
have the identification,
But-
and would be able to have somebody under 18 or under 21 there. Is that...
Well, they would be able to enter. I mean, they're able to
enter, correct.
Right. That is going to. I think we're kind of morphing continually. I mean, as I worked on this, it's like we clearly had the intent of focusing on bars, straight up what I know as a bar. Just what we all would define as a bar, and the intent of the bill was to address strictly the underage drinking that was being allowed in those facilities. But as we look at it, like you're saying, I would expect we'll have in 6 months a new definition of a way that alcohol can be served. So I think this is kind of a moving object. The intent of the bill is to acknowledge not every way. We're trying to acknowledge where we know problems exist, where we know the legal drinking age is not consistently being followed, and narrow our focus on that. And, I think we kind of get pulled in this way or that as really a distraction from what we know to be the problem. And I would really
what would you define the problem as?
Define the problem as alcohol serving establishments that allow illegal distribution of alcohol, either to at any level to an underage person, and sometimes to the point of damage to the person or a third party because of the person's intoxication.
Sure.
That's what I would say as.
Okay. And I would agree with you that any illegal act I've got serious concerns about. I think my concern and I that I guess I'll get into that a little bit on the questioning of the bill, but just wanted to make sure we're clarifying the manufacturing side with
Right.
It would be
Right.
excluding
The
breweries
amendment
and
The amendment
distilleries.
takes the manufacturing out of it.
Gotcha. Thank you.
Okay, there are no more questions on the amendment. The chair has offered the amendment. Any opposition to the amendment? With there being none, the amendment is adopted. Representative Edmondson, did you have a question on the bill?
Thank you. Senator Mizell, could you define for me, and for the people that don't know, maybe I'm the only one that doesn't, what's the dram shop law?
The dram shop law, I appreciate that you don't know, because I never wanted to know. But it's based on the old measures of alcohol from Old England, as I understand it. And the dram shop law allows for liability on the person serving the alcohol. So currently we have an anti-dram shop law, which means the person
not
serving
liable.
the alcohol is
not
immune
liable.
from
Yeah.
liability.
Mhm.
And this would allow, this would be like an incredibly limited dram shop acknowledgement, because most states have a dram shop acknowledgement for any age. I'm only asking in this bill for us to acknowledge the possible liability when an underage drinker who cannot legally be served is served, and damage is caused to the person who was given the drinks, or that person causes damages to a third party.
Which is what most other states have adopted.
They go, you're right, they go all the way up.
We're one of the few that don't.
And the liability
45 states.
would fall.
The possible liability.
Yeah.
And there, that there's no.
I meant that
there's-
possible, yeah.
There's no 100%.
Right.
Liability could be broken down because there's some layers of
Other
responsible
factors,
or
yeah.
irresponsible action taking place.
But for the most part, it would be the owner of the operation.
It would
of the
it would be
facility.
the server,
Yeah.
right?
The
right.
server.
So, the person who allowed the bartender to serve.
Okay.
Yeah,
That's
yeah.
what I meant.
mean the business.
Yeah.
Right.
Got you. Thank you for defining that for me. Thank you, Mr. Acting Chair.
Thank you. Representative Jordan.
Thank you, Mr. Acting Chair. Good. I don't know if it's still morning, but good morning, Senator.
Morning.
Good. Look, good to see you again. I know we always have good conversations surrounding broadband and
Yeah.
things, but here's the concern that I have, and I'm reading this. I want you, maybe you can explain this to me, and it comes to the liability. The way that I'm reading it, it almost appears as if you're creating a strict liability standard. And so I'm just asking for some clarification on that, or is this going to be negligence, or what it is, and then I may have some other questions to follow.
I'm not a lawyer, Representative Jordan, but I know what the attempt here is to create an opportunity that there would be a right of action and a cause of action.
I got that. So
Okay.
let me try to help you. Maybe I can follow. So would liability fall simply on the fact that someone served someone that was under the age of 21.
If that person were to then cause an accident to themselves or someone else,
That's right.
that's the way I read the bill.
So you read it almost as a strict liability.
Yes.
provision.
If you put the connection together.
Right, and so that's how I read. I read it the same way.
Mm-hmm.
And look, as a plaintiff's lawyer, part of me, I love that, and I don't want to see anybody get hurt or harmed, but I get it. But from a legislative perspective, I do have a concern about that because there could be some defenses, there could be some other issues at play. I know in Louisiana we have LA Wallet. I know that, I've been to different establishments with my physical license and they can scan the back of the barcode. But, and look, I know we read the stories. I know what's been happening around LSU and other college campuses and things like that without naming any establishments. But, we have a university that attracts students from out of the state and even out of the country. So I don't know if every state, if you would have the capacity to scan a barcode or what have you. I don't know what their IDs look like. I don't know if the bartender should be made responsible to know what all 50 states and other countries look like. And so if we're creating that strict liability standard, that's a concern. If it's general negligence, then, and I know you're not an attorney, so I don't know if you completely fully appreciate the question I'm trying to ask you, or my concerns, but the way I read it and acting chair reads it the same way. If it's a strict liability standard, I do think we need to address that because that becomes a issue that not only from a liability perspective and responsibility perspective, but I also think, just knowing what I know from my insurance background and serving on insurance, that's going to create, I can see premiums going through the roof because if you're going to be held to strict liability, nobody's going to want to insure that establishment.
But I'm going to.
So Jordan, the issue, and I know I'm trying to help out my friend, but I am in favor of the bill. I think the issue, though, that is more prevalent is that if I am 17 or I'm 16 and I'm in the bar, I know that I'm there. I know I'm not supposed to be there. I know I've bought the drink. I know I'm getting inebriated. I know I'm leaving.
I get the intent, and I appreciate that.
The liability would have to fall on the person who served,
but
this person who knowingly is breaking the law.
So here's the
Sorry,
question.
Senator Mizell, I wanted
No. So who's the person that's knowingly? Is it the person that's receiving the drink, or is it the person that's serving the drink?
Well, I think it's both because you have a duty. The person serving the drink and the person who works for the person serving the drink has a duty to the minor not to break the law, and that's where your liability comes in.
So are we calling minors under 18 or under 21?
Under 21.
Under 21.
So they're not minors technically. So under your example, I get what you're saying, 16, but we're talking about people maybe that are
They're
20,
under legal drinking age.
20. Well, no, I understand that, but for his example, I know he used the example of 16 or 17, but really what we're talking about
we can use examples of a 20-year-old kid too.
20. That's right.
I think at 20 you're still a kid.
No, I don't disagree with that. I agree with everything you have said to an extent. All I'm saying is, should we hold bartenders or people served to know the IDs of all 50 states, whether somebody's coming with a fake ID? If it's a legitimate ID and you knowingly serve them, I get that. I'm fully in support of that. But if you had a fake ID, shouldn't I be able to use that as a defense? If you were from another country, shouldn't I be able to use that as a defense? If it's a strict liability provision, the mere fact that I serve somebody under 21 makes me liable regardless of the defenses.
Maybe you and Senator Mizell can work on that between here and the floor.
And so that's part of my issue.
Senator Mizell.
If I could just make the point that if that's the way you feel, that we should not have the liability on the bar, then we need to make the drinking age 18.
No, that's not what I...
Well, it sounds to me that we don't want to...
No, that's not what I said, though. That's not what I said.
So explain to me what
So
exactly.
what I'm talking about is...
What he's trying to say is I'm trying to speed up the meeting. What he's trying to say is there should be some type of affirmative defense, as lawyers would use, if there was a fake ID situation and they thought the person was over 21.
If I may say, Mr. Leger with the ATC last meeting said that there would be consideration if the bar had a history of violation, say.
But that's from an ATC perspective. That's not from a legal perspective in court.
Testimony, I'm sure the ATC would be brought in and that they would.
No, not really. If it's a strict liability provision, all I have to show is that the person was under the age of 21 and that you served them and that some damages occurred. Once I prove those three elements, the liability is going to fall on them. And what I'm saying that, if it were negligence, maybe that's something we could deal with. But
I think what he's trying to say, I think what Representative Jordan's trying to say, Senator Mizell, is that maybe between him and the floor, you can work with him to create maybe a few affirmative defenses on behalf of the I guess retail owner, if they could prove that, look, it was a fake ID. This kid had a gray in his beard and his hair, and I thought he was over 21.
Well, look, I just think from an insurance perspective, I do think it's going to be problematic. But anyway, I've had my thank you, Mr.
Thank you,
Chair.
Representative Jordan. Representative Landry.
Yes. I grew up in New Orleans, and the drinking age changed to 21 when I was in high school, and we were all upset about it. But we kind of knew which places to go to that were not going to card you really hard or just look the other way. And I think all college students know that nowadays. But, I mean, my understanding is, this is regulatory. Like, ATC is over this, as we heard a week or two ago in here. If people under 21 if there's a bar that it's rampant, that's ATC's responsibility. So putting something in statute that is already the law that is already required, I'm just not sure we need to go here if ATC is already supposed to be responsible for minors in bars or under 21 in bars.
I think responsibility and liability is two different things. And what we're trying to say is that we're taking we're putting a greater value on the knowing of illegal drinking that is taking place with our underage drinkers. So, you're right. ATC it does the inspection. They can enforce it. We increase the violation amounts on here so that ATC would have a bigger hammer to use, and also we put half the violation amount to go toward enforcement because apparently they don't have enough agents to do what they need to do. But if ATC is one tool. The idea that we're going to say that we're standing by the law that underage drinking is a problem and drinking legally doesn't begin to 21, then if 45 other states say it's worth putting some protection on it, I believe Louisiana needs to be part of that number.
Well, I have also argued many times that we should do what other states are doing, and it seems like it goes back and forth here. But you're right, as we discussed a couple weeks ago in my bill, that ATC, I can't read my own handwriting. They can investigate, they can impose penalties, they can pull the license. They're an arm of us because we can't do every little thing. I have here in my notes that if they need funding, that's what we should give them. I'm just a little concerned about going further in the law when we have this agency that is already responsible for doing this, for what we want them to do, which is to prevent people who are under 21 from drinking.
But Rep. Landry, I think it's always a two-way street. We never put the sole duty of taking care of law by the enforcement mechanism. We always put some weight on those people who we expect, because they are a licensed business, there's an expectation that they're going to follow the law. And there's got to be some weight put on that. And the weight that is worked in 45 other states is that, okay, there's a liability component that we don't have in Louisiana. So we're saying that, wait, we really have a concern with what's happening with our underage drinking in Louisiana. We're going to address it by putting a weight on the people who are the givers of the drinks to the underage people. And by doing that, we're agreeing as a state to look at the way we've been doing it, which we're an outlier. we're an outlier, and we could talk about LSU and we could talk about our college campuses, but this is just one of those things that's you could talk about the culture, the rape culture. You could talk about the predatory environment we're creating around our college campuses by underage drinkers walking in and what's happening because of that. I mean, we see it in the news every day.
Mm-hmm.
So, I mean, I think this is one little piece. This is such a tiny baby step. Such a tiny baby step to acknowledge what we're allowing to knowingly go on, where our laws are being broken, and we don't want to touch them. They're like a protected group of society.
They are protected.
I
I don't think anyone disputes that, since at least I was in high school. But they can lose their licenses, which to me is just as much, if not more, that's a local issue. We all 18-year-olds in New Orleans where to go, and that is a problem locally with local law enforcement and ETC, and that is a bigger issue that is beyond this committee. But they can lose their license, which, I mean, the business is gone if that happens.
That just happened, actually.
Yeah,
But-
I did
but
hear
what
that.
What
Had to happen to get
Right.
there? Agreed.
Right.
They should have come down. I mean, everyone knows those bars outside LSU
Right.
are
And we all know
doing
it,
that.
so we're all complicit in allowing it if we don't put some weight on what we're able to do. We have the power to fix the loophole. We have that power. And I don't understand why we're so timid in using it.
We're one of 45 states. Why are we?
Right.
Why are
Yeah.
we one of
Why aren't
45?
we one of them?
I do have a
Good.
well, I don't know if it's a question or an observation for the other lawyers. I thought we did have a gross negligence standard. So I was just talking with Rep. Edmonston. If I showed up, falling down drunk and asked for 10 shots of tequila and they gave it to me, and then I, killed someone driving, I thought we already had a gross negligence, civil suit for the driver. I don't know for sure. Does anyone know? No, against the against the establishment or the server.
If look, here's the fact situation. I had a case like this.
Okay.
All right, here's the hypothetical. Someone comes, they charge on their credit card 20 drinks in a span of an hour, and they've drank all 20 drinks and they leave, and you get that credit card receipt. You've got a claim, okay? With Representative
Against both?
Yes. Well, what Senator Mizell's bill is trying to do is establish that, just like Representative Jordan hinted on, okay, that you don't have to, you wouldn't have to prove the gross negligence in the, I didn't know the kid was drunk. It's all about notice. It's all about, did you know? Okay. What Representative Mizell's bill would do would be, look, I just served the kid or served this person the drink. I didn't talk to him. He didn't give it one drink. Here's the credit card statement or whatever it is to prove that it is. So it's more of a strict liability bill on dram shop than it is a negligence bill.
Mr. Chairman,
Sure.
I'll take.
And I like the bill. I'm voting for your bill.
I'll take any question, but I think it's really important.
We do have some people that want to come
Right.
up to the
I think
table.
it's really important
Sir,
to put the
can you
bill
wait?
in perspective for you to hear
Sure.
from them.
Yeah,
Yeah,
I'd like to
okay. Shoot one question, Al, and then we're going to let the witnesses come up. All right, hang on. Representative Hughes has been in the queue a while. Representative Hughes, why don't you go, and then Alan, then we're going to have the witnesses come up. Sorry, Representative Hughes.
Thank you, Vice Chair, and I'll try to be as brief as possible. I was in Reverend Fisk, so I missed your opening. Madam Pro Tem, let me first by prefacing by thanking you. No one can question in this Capitol if there's ever been a champion for children in our youth. It is you. And you and I have partnered on so much stuff, and I just want to publicly thank you. No one can ever question your heart, and I mean that sincerely. What happened to Miss Madison, I mean, I publicly commented on that situation. It ate away at my soul, and so I understand. I just have a couple questions I want to make sure that I'm understanding. Okay, so if this bill is enacted in its current form, we have a lot of mom and pop bars that have been in business for many years. You may have a husband and wife that have been in business for over 50 years.
Right.
would their insurance premium potentially spike now that you're increasing these penalties dramatically?
Well, the penalties would be only on violations. So
Right.
if they don't have violations, they're not going to feel the penalty. But they're not even going to be required to have a scanner and do that, because that issue came up.
No, but the insurance premiums.
The insurance, I really, that's
In all likelihood, yes.
yeah. I mean, I did meet with the insurance people this morning, and at first they were not happy, but they're happier after the amendment. But I mean, we're not requiring them to have a scanner because they're not the issue.
No, but scanner aside, I just think,
Insurance.
I do think, looking at how the bill is drafted, I do worry, insurance is already high. And I think that if you increase these penalties, it will ultimately increase premiums. And I do think that will have some unintended consequences on our mom and pop bars. So it's just something to think about. Walk me back now, the age verification system. What did we do with that regarding the amendments?
The age verification system would be one approved by the ATC commissioner.
Every bar would be required to?
Only after having a violation.
Okay.
Which is why basically that gives the mom and pops, they're usually older drinkers, so they're not going to be impacted by having to go through the scanner if they've never had a violation, which I would expect that they wouldn't.
Got it. And if somebody uses a fake ID, what do we do in that situation?
What do you mean?
So if a minor walks into a mom and pop bar, they have a fake ID, the bartender checks the ID, but it's fake, the bartender doesn't know that, the minor gets intoxicated, is the bartender liable in that situation?
He would be liable, but it would be, he would be liable.
So if Miss Jane, who owns a bar, she's 72 years old. She's been in business for 40 years. A minor walks in. She doesn't know that this person is a minor. She asks the minor for an ID. The minor presents an ID. It's a fake ID. Looks real. Miss Jane doesn't know that it's fake. She serves the minor several drinks. The minor gets intoxicated. Mm-hmm. And so under that scenario, even though the bartender acted in good faith by checking an ID, didn't know it was fake, that bartender would be liable in that situation.
I mean, shoot, the underage drinker would have had to have been intoxicated.
Right, but the bartender, who's 72 years old, asked for ID,
right,
didn't know the ID was fake.
Right, and have all the compassion in the world for someone who's had a business a long time, but if you overserve a young person, so wait, what if she's 19 but her fake ID says she's 21? Why would you let a 21-year-old leave your bar so intoxicated that she can't drive?
But Madam Pro Tem, you can't necessarily look at somebody and determine their age. I mean, I'm 40 years old. And
no, but I mean,
some people say I look 21.
You may not be able to tell their age, but why would you let anybody leave your bar so intoxicated, whether they're underage or overage?
Well, but again, I'm really focusing on the liability. I can't get into somebody's intentions. But if a bartender,
right, what we could do though, Rep, we could just make it where they're liable all the way up. We could do that like the other dram shop laws, where they're liable for everybody they serve, period.
Yeah.
I'm only trying to address the fact that people are serving alcohol illegally and allowing young people to get killed. So, I would love to make this broader. I would love to make it where an 18 to 20-year-old can't go in a bar.
Yeah.
But, we brought it way down.
Alcohol... Alcohol impacts everybody differently, and yeah, and a bartender can serve someone, and they may not necessarily appear to be overly intoxicated at that moment,
right?
And over time, perhaps when they leave, they may leave in a worse state than when they were being served. But the provisions, I would just say in closing, I'm a little concerned that we do risk insurance premiums spiking, and so our mom and pop bars may be put in jeopardy if this is enacted. And the scenarios around fake IDs. Look, technology is getting more and more sophisticated, and fake IDs are real.
Do scanners for everybody. We could do scanners for everybody, and that way it would. I just don't
Yeah,
see
that
a lot of
concerns me too,
underage
because
in mom and pop bars.
well,
Okay, guys, we got a few people come to the table. We got go
Thank
forward
you.
one. Representative Seaball, real quick.
On the same note, I do have a question, and I apologize I wasn't here when your first presentation, or for the amendment. One of the things I actually liked about the bill when I first read it was the fake ID language. I believe it's on page 3. If the person is using a fake ID, the cause of action doesn't exist. But that was taken out by the amendment, and I want to know why.
Kind of what we just talked about is that if you excuse every young person that comes in and uses a fake ID, the scanner's going to pick that up. The only way you're seeing the prevalence of fake IDs right now is because, frankly, most bars want fake IDs to come in.
Okay, but hold on. You're talking about two different things.
Uh-huh.
The age verification system, I believe, only comes in after there's been a violation.
That's in there. We put it somewhere else.
But only after there's been a violation. You don't have to use it all the time.
Right. And it was because to address the concern of the mom and pop and the older small town bars.
But the cause of action exists before the violation. So the cause of action exists, and I mean, here's I guess where I'm coming from. You have culpability. Who's at fault? You have a minor who's using a fake ID, who knows they're doing something wrong, and then you have the bar owner who looks at the fake ID, thinks it's real, doesn't know they're doing anything wrong. The person who leaves, the minor who knew they were doing something wrong, has a drink, leaves, either injures themselves or injures somebody else, and they're not responsible. The bar owner is, who didn't know he was doing anything wrong. I have a real problem with that.
Well, I mean, we could make it where the scanners have to be used everywhere, if that would ease your concern.
Well, I guess what was the problem with the initial page 3, lines 6 through 12, that says if the person's using a fake ID, the cause of action doesn't exist?
Because I think that there's too many kids using fake IDs that it's a free pass for every kid to go into a bar and for a bar to say, I can't do anything about it, not my problem.
But your
And then
bill
that-
provides protection for the kid.
The what?
Your bill provides protection for the kid who's breaking the law. That's the part that I have a problem with. The one who's deliberately doing it wrong, they go out and have a wreck and injure people. The bar owner's at fault, not the kid that went in there knowingly using the fake ID. You're protecting the bad actor. That's a part that I have a problem with. There's got to be some way to fix this, and this is not it.
I think we're looking at this totally differently, because right now, the kid's the only one responsible right now. The bar's not touched right now. So
You mean before the bill goes into effect?
Right.
Like as we
Yeah, the
right.
bar's totally scot-free, even though they can willingly or unknowingly. Now, we can make it where they're totally aware or they're totally unaware, like you're talking about. They may know that there's no way that kid's 21 or whatever. They whatever. But either way, there's got to be some shared responsibility with the bar. Right now, there's no responsibility with the bar. The worst thing that happens is like a $50 violation.
3 minutes.
And when that happens, so this is what has proven when the dram shop law goes into effect and there's liability on the bar owner becomes more engaged in the way he handles the fake IDs. Right now, there's no liability for the bar to take in every fake ID that comes to his door, knowing or unknowing.
I guess the other problem I have, the bill, as I've read it, does not have any language in there about obviously intoxicated, over intoxicated. All it says is the minor purchases alcohol. It is impossible to prove where a person had a drink. If a person goes to a bar and has 2 drinks, then they go to the friend's house and have 2 more, then they're involved in a wreck. You check the credit card, you see they bought them at the bar, all of a sudden the bar owner's responsible. They might have gotten intoxicated somewhere else, and it's impossible to prove that. But your bill creates strict liability. If they purchased it there, even though the bar owner had no idea they were doing anything wrong, they got intoxicated somewhere else, the bar owner's still liable. I just think you're opening a huge can of worms here. And the insurance thing is I don't think any bar will be able to get liability insurance in Louisiana anymore if this
of course
passes.
they can. 45 other states do it. Of course they can get it.
45 other states don't do this. They don't do this. They do the knowingly intoxicated, the dram shop thing. If they do that, they don't have strict liability for serving alcohol to someone using a really good fake ID. That's not what 45 other states do. And I think this, honestly, I understand your intention. I'm completely sympathetic. I think this is a horrible bill.
No, you know what, Rep. Seaball, we've all been sympathetic. It's time we do more than show sympathy. I've said it already. We have the power to do something. If you don't like this, for goodness sake, show me what you like, because we've got to do something. And I really have nothing more to say, but I'd love.
Yeah, well, let's call some. And Representative, we're going to get to your question. Let's call up some of the witnesses we have. Well, hang on.
I don't think you can fix them.
Are you Miss Melissa? Brandy Melissa? Ashley, okay. Ashley Bouster. And then let's bring up Brandy Melissa. And then Paula Zachary. Okay. Ladies, we got to be on the floor, so we're going to implement the 3-minute rule. And so, Ms. Boussart, 3 minutes.
Oh, I'm Brandy. Most of y'all know. Some of y'all don't. My brain scan February of this year. The radiologist that was not familiar with my situation said a result looked like postoperative changes from a frontal craniotomy. I've had a skull reconstruction in 5 months, but I've never had a craniotomy in my life. This was caused by somebody who drank from the time he was 14 years old. For the last 15 years, I have lived less than a mile away from Reggie's. If ATC did that job, that place would have been shut down decades ago. The store at the corner, those kids would frequently come in there intoxicated with their bands on from Reggie's, proving they were underage. Wanting more alcohol, but people knew what bands were, so they would tell them to get out. I can't even imagine what this family sitting next to me has had to go through their minds listening to what's happened in this room so far. Senator Mizell has bent over backwards for kids and youth in this state since she came to this building. I don't always agree with her, and she knows it. One of her first bills I vehemently opposed. But for the sake of another matter not happening, y'all need to start somewhere. I don't agree with the way everything was changed in this bill, because personally, the bar right next to Reggie's, you can't get in there unless you're 21. That should be state law across the board. If ATC did their job, Maddie Brooks would still be alive today. And so would other kids that have lost their lives from being served alcohol under 21 from Reggie's. That child would still be alive today, and these people would not be grieving the loss of their child that probably would have graduated LSU this year. But now they have to visit a gravesite because ATC failed them and failed future people. And it only took that story happening on the news for anything to be done, and that's only because of what happened to her after.
Yes, ma'am.
So the opposition to this bill really needs to think about that. Thank you.
Thank you, Miss Melissa. Miss Zachary.
Good morning, Paula Zachary, and I appreciate some of your comments. My son Brandon was 19. He was enrolled in Southeastern. He was in criminal justice. He wanted to be a U.S. Marshal. One more time before the fall semester was to go back in. He and his buddies went to Hammond. They were at the doghouse. It's no longer there. I have debit records that showed where he purchased that night, right at $100. I went through his things after he was killed. He did not have a fake ID anywhere in his belongings. We went to ATC, and they told us we did not have a leg to stand on. We need this bill to help us. We are grieving moms. We are grieving families. And it's been 15 years, but I have to go the rest of my life without my son. I have a voicemail, and I'm going to share it with you real quick. It won't take long. It's brief, and I don't know very many of my friends that have lost loved ones that actually have a voicemail. I'm sorry, I'm nervous. I'm getting it. But you'll hear his phone ring, then you'll hear Brandon.
Can't make it to the phone. Leave me a message and I'll call you back. Later.
This is what I have of my son. I am with Mothers Against Drunk Driving, and I do a walk every year with them. And my team name is Later, because I know I'll see my Brandon again. I have a picture of his truck. When he left Hammond that morning, a little after 3, he crashed on Highway 1019 north of Walker. I don't know what happened to him in that hour, and we'll never know. He was not supposed to be there. He knew better. He was raised in a home that we didn't have alcohol, and yet that prefrontal cortex of the brain is not mature until they're in their mid-20s. He made a very stupid decision that night. He had a plan to go home with his friends, but he didn't have a backup plan. And yes, it might cause the insurance companies' premiums to go up, but it has cost me my son's life. And that is the main purpose, if we can save another family from going through this. Thank you.
Thank you, Miss Zachary. Okay. And we have is it Bussart?
Balster.
I'm sorry.
It's okay.
Yes, ma'am.
Good afternoon. My name's Ashley Balster, mother of LSU student Madison Brooks, who died tragically on January 15th of this year. My daughter's death is a tragedy that never should have happened. 3 of the 4 perpetrators in this act of violence were under 21 and never should have been in the bar in the first place. Numerous violations occurred that night, all involving underage drinking and serving, which could have been prevented. Many of the bartenders that night that were over serving her were also drinking and consuming alcohol. This bill is a step in the right direction, although I firmly believe it's time for Louisiana to join the rest of the country and prohibit anyone under 21 from entering a bar and serving alcohol. Not one employee that night was responsible. Our current system failed my daughter, which helped to facilitate her rape and ultimately cost her life. There are way too many underage students who, like Maddie, can drink and serve under the current laws. Too many businesses are turning a blind eye and profiting with the current laws and penalties we have in place. The bars are not regulating underage drinking, and Maddie's case supports that. The statistics prove crimes and deaths will be reduced substantially if this bill is passed. There isn't a price tag on saving lives. My daughter is no longer with us, but you can make a difference today. My daughter is dead, and everything with this tragedy could have been prevented. Many of you are parents. Imagine, for 1 second, losing your child to these circumstances. Just for 1 second. Be the voice and make the right call. Please, please, for my daughter, and help save lives.
Thank you, ma'am. Thank you, ladies.
One thing.
You can.
I don't know what our BAC was, but when Brandon,
0.319.
When Brandon was killed, his was a 0.19. And at these ages, they should not have been over a 0.02. Thank you.
Thank you, ladies. Thank you very much. Gene Mills Family Forum. He waves. Okay. Also filling out cards in support are Dr. Paul Will Hall, Louisiana Baptist Office of Public Policy, Amanda R. LeBlanc, self, Dell Hoffman, Louisiana Family Forum, David Blackwell, First United Pentecostal Church of Holden, Pastor Tim Grant, Lion Gate Church, Michael Ziegler, Pastor Pentecostal Ascension, Reverend Jose A. Luke, United Pentecostal Church, Pastor David Hareform, United Pentecostal Church, Sidney Lacara II, UPC, Steve Gautreaux, United Pentecostal Church, Kenneth Stewart, Pentecostal of Watson, UPCI, Chad Mills, UPCI I'm going to get there. Apostolic Tabernacle of Fellowship, Tom Costanza, Louisiana Conference of Catholic Bishops, and Holden LeBlanc self. All cards in support. We do have some cards in opposition that we wish to come to the table to speak. They haven't filled out a card. I have no white cards. Let me get the opposition first, and then we'll get them up. Jason Ney and Eric Sunstream. Okay, gentlemen. Jason, 3 minutes.
If I could start, Mr. Chair, Mr.
Sure,
Director
Eric,
Chair.
go ahead.
Eric Sundstrom, representing Freds in Tigerland. We have worked with Senator Mizell since the bill was introduced and thought it was in a very good posture leaving the Senate. And unfortunately, the amendments that the committee adopted kind of required me to come up and bring something to y'all's attention, that the playing field was shaken up a little bit. You know, taking breweries and distilleries out, they, for all intents and purposes, act as bars. They are family-oriented places. Kids under 21 go with their families. Under 18 go with their families. And as I understand the amendments, they are now taken out and we are standing there alone. Packaged goods stores are also those that could be included, as they certainly sell to underage and should be held liable for doing what they're doing. So I just wanted to bring that to y'all's attention. I appreciate the time. Thank you.
Thank you, Eric. Jason?
I'm Jason A. I've been working at Fred's for 20 years, graduated from LSU, and stuck around. Fred's has been open for 41 years, and we pride ourselves on we're not just selling alcohol, we're selling memories. We've had Snoop Dogg perform, Shaquille O'Neal performs every single year. We do our best to give the college students a place to meet people, to meet their next wife, to meet friends, and really enjoy themselves. And we try not to make it just about the alcohol. And we don't always allow 18, 19-year-olds into the bar. Sometimes we do. We have parents' events. We have crawfish boils. We have dry fundraisers for sorority events. It's not just about drinking for us. The scanners, I wanted to touch base on the scanners. ATC's worked with us on the scanners. They're not perfect. It needs just like the court reporter thing earlier, it's not quite ready for, you need a human behind it to kind of make sure everything looks right. We can record every single ID that gets scanned, but if it's a misrepresentation, if it's somebody else using another person's ID, then we won't have that recorded to defend ourselves versus liability later. We've run this paperwork by some of our lawyers, and we think we're going to get dropped immediately by our insurance company. With the way the wording is right now, we think we're getting dropped, like no doubt. I mean, our rates already doubled after COVID for some reason. Still paid insurance all through COVID, even though we were closed. But I just want to say thank you for your time. And the scanners are getting better, but so are the fake IDs. We try our best to do what we can. And thank you very much.
Yeah, thank you, gentlemen. Okay, also filling out cards in oppositions: David Cook, Louisiana Bar Owners; Jeff Vaccaro, the House; Andrew Kilshaw, Louisiana Association of Beverage and Alcohol Retailers; Chase McDougall, the House; Luke Falgoux, the House; William Schulter, myself; Carly Vidal, the House; Crawford Stewart, the House; Will Dubois, Louisiana Restaurant Association; and John Williams with the Beer League. Mr. Leger, you here? ATC? Come on up. I think Representative Hughes has a question for Mr. Leger. And then Representative Jordan as well. Representative Hughes, hang on just a minute. There you go. Go ahead.
Good morning, Mr. Acting Chair. Ernest Leger, ATC Commissioner.
Thank you, Vice Chair, and thank you, Commissioner. Really briefly, I just wanted to get your perspective on the amendments from ATC's vantage point and the bill now in its current posture.
So, first of all, I've appreciated many conversations with Senator Mizell and completely support the effort to try to bring attention and some additional regulatory scheme to a problem that has faced the agency since it has been in existence. It is our chief concern and our chief responsibility. The agency conducts thousands, literally, we average 6,000 compliance checks with respect to underage compliance on the over 10,000 permits that we have, alcohol permits that we have in the state on a yearly basis. The current regulatory structure does not allow, it's a progressive penalty type of situation, right, where the fines and penalties and ultimately whether or not a business can be suspended or revoked, the opportunity for that as a penalty increases with every new offense. So it's progressive in that regard. However, we hold hearings on a monthly basis, and every hearing month routinely suspend and revoke permits of businesses that do not take this responsibility seriously for both alcohol and tobacco violations. As it relates to your specific question, I express and have been very candid that I don't like the idea of cherry picking business types. If we are going to undertake this effort, it should be done uniformly and consistent among permit types. I think in the Senate, I specifically mentioned that manufacturers have manufacturing permits, but their principal within the law right now, if your principal operation is the manufacturing or distilling or brewing of a beer or a spirit in the case of a distillery, you're not allowed to have on the premise anyone under the age of 18. In an effort to bolster that community and to foster and give more business opportunity, my predecessor put out an advisory that allowed certain additional rights, and that is how we have developed this industry with tap rooms, where we are allowing, despite what the law says, families and underage individuals to go in order to try to grow the culture around these businesses. But presently, right now, the law in a brewery and a distillery does not allow someone under the age of 18 to be on the premises, period. To take and cherry pick them and remove that operation that functions as a bar, essentially, although it is permitted a manufacturer, out of this equation, I don't think is fair. It's not fair to single out bars, and mind you, our agency regulates the entirety of industry. We regulate all of the permits, and we want to see a healthy and fair market, and we want to see the rules apply to everyone the same.
Thank you, Commissioner. Thank you, Vice Chair.
Thank you. Representative Jordan.
Thank you, Mr. Vice Chair. Look, couple of questions for you. As it relates to these scanners, and I know we have Louisiana, and I know we got the barcodes, and we can do that. Does that work, or the technology allow for all 50 states and international IDs to be scanned as well? So
it depends on what I'm going to first of all say. I don't think anything is completely foolproof. The best example I can give you is bulletproof vests, right? We make technology advances with respect to bulletproof vests, and criminals make a better bullet, right? It's constantly evolving. The same thing exists with respect to scanners. They're different types of scanners. Real-time verification is an awesome one, right? But as someone correctly pointed out earlier, it's dependent upon a human being in order to interpret the information and make the ultimate decision as to whether to allow someone in the premises or not. If the individual or the business does not have the care, the want, the desire, then even the best of equipment is not going to solve the issue. Is that fair?
That's fair. That's fair. And I know the senator could not speak to the insurance perspective, or if this bill would pass under this strict liability scheme, what would happen to insurance premiums, to the ability that, to the extent that you can address that. What is your opinion?
Well, I'm pretty limited in that regard. What I can say, and we did have a conversation, and I agree that if so, Senator Mizell correctly pointed out that when we are deciding what is the appropriate remedy given a violation, we take into consideration all of the factors, and we structure a response based upon the facts at hand. And each particular situation is a different variation, right? In a strict liability scheme, there's no allowance for mitigating factors on behalf of a responsible business owner. I suspect, also being a lawyer, that would present more of an opportunity for liability. And if I am an insurer, I'm not in that business, but if I am an insurer and there's an increased risk of liability, then I'm going to probably charge a higher premium in order to insure that business. But that is coming from essentially a layperson with respect to insurance.
So then, and I'm glad you, because I wasn't sure if you were a lawyer, but I was going to ask you that question. So from that perspective, and are we shifting responsibilities now? Because under strict liability, there's no comparative fault.
That's correct.
So we're going to a system right now to where there is no liability, or very limited liability on an establishment right now. Is that correct?
So I don't practice in this area, so I want to be careful that I don't say anything that's not completely appropriate. But under the most egregious of circumstances, if you can meet or exceed the legal standard, and I think there ultimately can be and is in certain situations some liability.
Yeah, limited though.
By far exceed what is available now.
Right, but we're almost shifting it now to where there would be, and even under the scenario as Representative Seabaugh said, even a bad actor, an intentional bad actor, there would be no liability or no account for that.
I honestly don't want to speculate.
All right, don't worry about that. I just think it would be, and this may not be for you, but so this is probably more of a comment. I just think it'd be better if we had some type of maybe potentially negligence scheme where there would be some comparative fault that would limit, not necessarily bar recovery, but might limit it in some sense.
Representative Jordan, I appreciate your concern and your sentiments, but I'm going to leave that question.
That's fine.
For,
no
for,
problem.
For you guys to
no further. I don't have any further questions.
Representative Landry.
Oh,
I'm sorry. Okay, Representative Presley.
Commissioner, please tell me about your compliance checks a little more in detail. How many have we done in the last year?
Absolutely. So I don't have a definitive figure. What I can tell you is that the agency currently receives 2 federal grants, specifically to allow for overtime for our agents to conduct compliance checks. A compliance check is it's essentially an operation. It's comprised of an agent, a witness, and an underage operative. The underage operative is obviously underage, cannot lie, and even has the vertical ID that shows that you are an underage individual. We visit the targeted locations on one grant and have the ability to, on the other grant, select the locations ourselves. But we go into grocery stores, package stores, bars, restaurants. It doesn't matter the license type. The underage individual will go in, try to purchase, at the very least, an alcoholic product. But in certain cases, when there is also a tobacco permit, also tobacco products, the witness is there, and if there is a sale, the agent also visits the site, takes pictures of the evidence, writes a report, and also writes a citation.
Who's fined in that process?
I'm sorry?
Who's held accountable? Just
Both
the person that's
server
sold?
and the business are fined in that situation.
If they're gross violations, what happens?
Gross violations, I would indicate would be a third, a fourth, or more offense.
Okay.
I'm sorry. Go ahead.
And I guess my question is, if you walk into a bar, if there's a ATC operation going on, and let's say you find out in that operation that multiple or dozens of underage kids are there and drinking, and clearly it's a gross violation, what happens? Can you revoke their license at that time?
I had the statute gives the discretion to revoke in any situation where a public safety issue outweighs the not the right, the privilege of the business.
And have you used that?
Absolutely, yes, sir.
How many times have you used that? Let's say in the last 5 years.
Given most times it is egregious situations where there have been 3 or 4 violations within the 3-year cleansing period, right? I could probably testify truthfully that on a monthly basis we may revoke the permit of 2 or 3 businesses.
If you had more money in the budget or in your operation, could you do more?
Absolutely. We testified before. At this point, we got 30 agents that are responsible for, I mentioned, over 10,000 alcohol permits, but that doesn't include the thousands of special event permits that we have, the thousands of tobacco permits we have, the 2,500 CBD permits that we have with responsibilities in all of these situations, and the agency investigates 100% of the complaints it receives. So we are spread thin in terms of the manpower that we have. We cannot be in all places.
Do you coordinate it all with with local law enforcement, with sheriffs or local police?
Never turn down an opportunity to partner with local and law enforcement in order to address specific problems with them.
When ATC and our locals are finding underage kids utilizing fake IDs, whether they scan or not, do we hold those bad actors accountable as well?
What we have more success doing is citing an underage individual for something called a minor in possession. It's an individual on premise, has a drink, and is not supposed to have the drink. The issue with that is it is a municipal violation, and we have I'm looking for the politically correct way to say this. We have varying participation with local jurisdictions in terms of prosecuting those. Is that fair?
That's fair.
All right.
Commissioner, I'm concerned. I think everyone in this room is concerned.
Yes.
I think everybody at this dais is concerned about making sure that our bad actors are held accountable. I don't think there's a person here, an organization, a group. Bad actors need to be held accountable. We need to make sure that we do that. I respectfully request that your agency do everything you can, and I know you're doing so. Work with us, help us to understand what else we can do to help on the enforcement side to do more.
Yes, sir.
Because there's no doubt we've got to hold people accountable.
I agree.
Thank you.
Yes, sir.
Representative Edmondson.
Thank you, Mr. Acting Chair. Mr. Leger, thank you for being here. I just have a couple of questions. If you're getting 2 federal grants, you said, and those grants help you to kind of run your, for a better word, undercover sort of a operation. Okay. If you didn't get those federal grants, well, how long have you been getting those federal grants?
Well, I've been here. I've been in the agency 7 years. They've been here at least that long.
Okay.
But there's also the grants are helpful because we're self-generated, right? We don't get anything from the general fund. But overtime is not required in order for us to do a compliance check. We can do that in our regular course and scope as well. It is a great assistance to the agency to get these grants, and they do help.
It sounds like it is. The other question I had was, do you, when you hold your hearings, you obviously had a complaint or a reason to hold a hearing. How do you get those complaints other than a horrible tragedy that occurs, and you can pinpoint the bar or whatever, you know?
With respect to hearings, those are not necessarily the result of complaints. When our agents write a citation or we take a suspensive action on a business, the business is entitled to a hearing.
Right.
Those hearings are conducted, and we ultimately make a determination. Complaints come to the agency directly to agents or staff, and we log a complaint, assign it to an agent for investigation, and track it to completion. Or you can go online to our website and anonymously place a complaint, and the same process occurs if you contact the agency that way.
Do you get many complaints, and the nature of the complaint?
So yes, we get lots of complaints, and they range anywhere from hey, this business is a problem with respect to serving underage individuals,
right,
to a competitor across the street ratting out the business across the street because they feel they have a competitive advantage.
But you do. It sounds like you have the public has some concern about this.
Oh yes, ma'am. I think as evidenced by all of the testimony and all of the folks that are here today. I think
but they have issues, you know, with their children. I mean, tragic events. But I'm talking about just the general public has a concern about underage drinking in bars.
I would agree. Yes, ma'am.
Thank you. Thank you, Mr. Acting Chair.
Thank you. Representative Landry, you have a question?
Yeah. Just kind of what I asked before. I mean, you've been in here numerous times, and y'all have the power to pull a license to shut them down, and that, I mean, effectively that'll end most businesses.
That's correct.
And I know y'all do that, and I know you have to work with locals to do that, because you can't be the cops in every parish. You work in conjunction with them.
We have the right to be
you can
facility that has our permit at any time.
Right, but just saying it's functionally,
yes, ma'am,
you have to work with them. I know, talk again about when I was younger, and that was the big threat. ATC's coming in here tonight, and that was enough to get everyone out of here. And just like Thomas was saying, I mean, if y'all need more funding or agents, I agree with that. Another of my committees had a bill that was going to move a power from one agency to another. And the issue was, if this agency isn't doing it, then we need to work with them in funding and regulation. So, you know, you and I are at odds often, but I know this is your job. And this is what y'all are supposed to do. And if we can help you out with doing it, and of course it is on the bars, and maybe they need to know that you're coming around instead of twice a month, 10 times a month, to really get their house in order. Because it's known. It's generally known where this is happening. It's not a secret to anyone. You can ask any of the 19-year-olds who walk out. So I would like to see if y'all, you know, need some ramping up.
I'll repeat every time I get here, I remind everyone who will listen that we do what we do in the state with 68 full-time employees.
You need more than that. Yeah.
All right.
I agree.
Thank you.
I'll get you some money if I had some.
Representative Ogeron.
Mr. Acting Chair.
Representative Ogeron.
I'm Representative.
I didn't hear my name.
Yes, sir.
Sorry there, Mr. Vice Chair. First of all, thank you very much for speaking with me about my concerns about the microbreweries and things like that earlier before session. And I know Senator Mizell always brings bills that take care of our youth and young citizenry of Louisiana. But something still, I actually came in here thinking that the scanning of the ID cards was more foolproof than what this testimony has led me to believe. So what I'm grasping with right now is if you have, and I'm not in restaurants, bars, or microbreweries. I'm talking about now college. Let's call them college town bars serve primarily alcohol. They get a license. The owner gets the license from ATC. He tells all of his servers by absolutely no measure do you ever serve to underage people. That's the going standard. An ID card is shown in vertical. Immediately out you must go. Okay, but if the bartender, the owner are all good actors, and someone has a fake ID, and even if they have the establishment has the scanner, and the scanner shows valid or something like that, 21 years old, and that bartender serves that person alcohol, and they subsequently get in one of these incidences where this law goes into play. What is it that the owner, operator, and bartender did wrong? I mean, didn't they do everything correctly? If there was any, I mean, I hate to put it on the person that got the fake ID, but that seems to be where I mean, I'm having a tough time supporting a bill that might punish, bars and owners and bartenders whenever they did everything appropriate.
At the end of the day, the businesses that take this responsibility seriously and do the best with respect to compliance are the ones that have several layers of effectiveness through policy and training, right? Lots of bars have zero tolerance. Lots of businesses have zero tolerance policies, right? If you sell to an underage individual, you're fired. End of story. That's a great incentive for a bartender or a clerk not to sell to an underage person, because I'm going to lose my job. They're going to make sure that they look at that ID as best that they can. Everybody doesn't do that. Right?
Whenever the owner fires his own cousin or his own relative or whatever, it makes a statement. Got it.
Our agents will conduct trainings at any business where requested, where we will take you through and talk about any and all situations, answer any questions, and provide some levity and seriousness to this responsibility, right? If you have point of sale services where it's not simply you're 100% relying upon someone to casually look at a license, but you have to swipe an ID or input the information and the cash register will not allow the transaction until that information is appropriate. That's another measure that you can take. You do all of those things, and then you are being as responsible as you can with respect to this operation. But at the end of the day, within a hearing, the business is still ultimately responsible for the service or sale to an underage individual. Someone correctly pointed out earlier today, it can happen in those situations. That is where the violation would have a business end up on the lower scale of a violation and a fine, as opposed to a business that has taken no steps, doing nothing, and not taking the responsibility seriously, right? If on a first offense the statute allows me up to $500 fine, which is what it is, that the irresponsible business would get a $500 fine. Another business that's trying to do what it can, but had an employee that didn't follow the training, didn't follow the procedures, so forth and so on, may get a $100 fine for a first offense. But again, it's taken on a case-by-case basis.
Understood.
Yes, sir.
All right, thank you.
Thank you, Representative Edmondson. And I'll remind members we have to be on the floor at 1.
Yeah.
I'm sorry. I thought you had a question.
Yeah.
Okay, that's it. Thank you very much.
Acting Chair.
Senator Mizell. Senator Mizell, would you oppose an amendment from the chair that would institute a concept form of comparative fault?
No, thank you, Mr. Chairman. I was going to discuss that.
Okay,
So
okay. Let's staff. You ready? You ready, buddy? All right, Ms. Lewis. Okay, why don't you read the amendment for which we're working on?
Alrighty, members. So if you go back to where we removed on page 3, those lines 6 through 12, we'd be putting back a paragraph 4, which would say the damages incurred by the underage person consuming the alcohol beverages shall be reduced by any comparative fault attributable to the underage person on any other party.
And what the amendment's intended to do would be to address Representative Seaball's questions and Representative Jordan, in that if you had a fact situation where you had you used to learn a kid that left the bar, maybe had one drink at the bar, but then went to an adult at someone's house and then had 10 drinks, it would be the fact finder's responsibility and the plaintiff's attorney, whoever did it, or the defense attorney when they're coming to the defenses, to put where the kid got drunk, where he got inebriated, where he went from point A to point B, and allocate the comparative fault law that we have in Louisiana now. So it wouldn't be 100% fault on necessarily the provider. You may have some fault on the provider. You may have some percentage of the fault on the kid, and you may have a percentage, or his parents, or a percentage of the fault on where he, if he was inebriated somewhere else. So it's intended to make the bill better, so we can maybe try to get it to the floor. I don't think Senator Mizell has any opposition. Do you, ma'am? No opposition to the amendment? Okay.
No opposition.
Does anyone else have?
Yeah.
I'm all for the amendment. Does anyone else have any opposition? Sure. What the amendment is intended to do, Alan? No, it's not. I did it here.
I can repeat it.
Just trying to, but what the amendment is intended to do, okay, is create a comparative fault situation by which, in your hypothetical when you were asking questions, is that, how do you know he got inebriated to a point of negligence, or at a point at the bar? Maybe he stopped at a friend's house, or maybe he stopped at the fraternity house, or maybe he stopped somewhere else. This would create a mechanism for a comparative fault situation to actually hold liable the bad actor. We're putting paragraph 4 back, and then we're adding that language.
You want to do both? Or you just want? It just. We're still deleting that, yes, sir.
And we're replacing it with this.
If number 4 becomes this, no, sir.
Just trying to make it a little better so we can. And I think that from what I'm hearing, Senator Mizell would be open to a lot of suggestions between here and the floor.
Right. I think.
But let me tackle the amendment first. Is there any opposition to the amendment of the chair? With there being none, the amendment is adopted. All right, Senator Mizell, close on your bill.
Actually, that had been discussed previously, but I wanted to address a couple of things that I heard from this table.
Yes, ma'am.
The question was asked by you, Representative Presley, how many revocations had taken place? Did you get a number? Oh, excuse me. Well, I don't believe you got a number. I didn't hear a number, and there is no number. So the cleansing period being 3 years with ATC, it's really hard to revoke a license unless there is some horrific situation that takes place, because if they're only going to a bar once a year, maybe, within 3 years, it would take a lot to revoke the license. The other thing is we require scanners on any purchase of any alcohol. So if scanners are pointless, then I don't know why we require them on every other purchase of alcohol. So those were just, those bothered me. But I'll close. I know you've got to go. But I think it's really important when we hear bar owners talking about making memories that we take some responsibility in the kind of memories we're allowing to be made. And we read horrific headlines that should demand some responsibility from the bar owner and some accountability by us. So thank you, Mr. Chairman. Thank you for your help on the bill and your cooperation with the changes.
The chair is making a motion to report SB 194 as amended to the floor. Any opposition? Representative Seaball objects. There will be a roll call vote. Again, this bill, we could work on it between here and the floor, but we'll have a roll call vote. Yes is to move it to the floor as amended. No would be to not.
Representative Gaines? Yes. Representative Edmondson? Yes. Representative Hughes? No. Representative Johnson? Yes. Representative Jordan? No. Representative Landry? No. Representative Mack?
Yes.
Yes. Representative Muscarello? Yes. Representative Orgeron? No. Representative Owen?
Yes.
Yes. Representative Presley? No. Representative Seabaugh? No. It's 6-6.
Motion fails to carry.
Thank you, Mr. Chair.
Thank you.